Clock.
Thank you, Mr Chair. I was looking for the motivation for this change in such traditional rights that we've defended over many generations, and it seems to be all about money. We're going to save a bit of money, save the trouble of transporting defendants from their cells to the courts, and just save a bit of money here, a bit of money there. And really, we can't sell justice like that. And as I think Charles Chevelle pointed out, we might save a few dollars by having the video links from the prisons through to the courts, but we're going to lose a lot more because this law will not last. There will be all sorts of challenges to it, including, as Charles Chevelle said, appeals up to the United Nations Human Rights Committee. There is an international backdrop to justice now that can be appealed to. And as has been pointed out by my colleague Kennedy Graham, by Charles Chevelle, it's such a fundamental right, the right to be present at one's own trial in both the Bill of Rights, the International Covenant of Civil and Political Rights, etc., etc. And there's also a phrase that justice must not only be done, but be seen to be done. And it's ironic if it will be seen to be done by those who happen to be in the court at the time, the judge, the lawyers, perhaps some media, perhaps some people in the gallery. They will see justice supposedly being done, but the person it most affects, the person who might be imprisoned, who might be there, sent away for life, that person isn't in the court to see justice being done. And that is such a huge injustice, and what it will lead to is a great feeling of those who get convicted in this way, a feeling that they've been wronged, and they will be very bitter, and there will be a problem, in some sense rightly a problem in the prison system, because they will carry that feeling that they have been wronged for a long time. And there'll be in the community a lot more cases like the Thomas case, where people think this person was wrongly convicted, and one of the reasons they were wrongly convicted was that they weren't present in the court and they didn't get a fair go. And those who will suffer, as my colleague Materia Ture and Honi Harawira have said, those who will suffer most will be the people that are the most marginalised in society, the people that don't have all the nice suits and well-appointed relations to, in a sense, give them some protection. It'll be people who haven't got much money, people who have had problems in their past life, etc., etc. So it'll only lead to greater differences in the application of justice, as my colleague Materia Ture said. Now, I've been on a jury in a fairly long trial, and actually, and one of the things that struck me being on that jury and being part of the deliberations is that the body language and what is said directly, the way people look, the way their eyes flicker, all of those things when defendants are giving evidence are very influential on the jury. I could see it. And in this case, there were sort of two people with two versions of the truth, arguing quite passionately for their side of the case. And a lot of the judgment I could tell from the jury was on how, the body language, the subtleties of how they presented their case, which wouldn't have been picked up on any video. And also their ability to see each other and how each other sort of reacted was quite important in this case, or at least the defendant and the main witness against the defendant. So I think that it's important not to proceed with this bill, and I do support a delay, and I do support the amendments put forward by David Parker and Kennedy Graham. Thank you.
I call Leanne Dalzell.
Mr Chairman,